In this second mini lecture on freedom of religion, I want to talk about the second component of freedom of religion, which is the free exercise clause. You may remember in the first of these mini lectures, I talked about the establishment clause. Now, when talking about the free exercise clause, the court has often distinguished between belief and practice. The justices have said that the court couldn't, shouldn't, and wouldn't engage in thought control. And yet, that does not necessarily mean that you're always free to act on those beliefs. And this distinction between belief and practice can be very, very elusive, because even the notion of whether an activity is legal or illegal may not be a very good guide. For example, during Prohibition, the consumption of alcohol was illegal, and yet Catholics were given an exemption to drink wine as part of communion. The Navajo have been given an exemption based on religious grounds, for example, to imbibe in peyote, which is a hallucinogen that violates federal drug laws, and yet they're allowed to do so. A Caribbean group practicing Santeria, which involves rather gruesome animal sacrifice, has also been allowed by the court. And yet at other times, some activities have been allowed and some haven't. For example, the Amish. The Amish have been given exemptions to mandatory school age attendance requirements in the state of Minnesota, for example. On the other hand, the Amish have not been allowed an exemption in Pennsylvania to have buggies without reflectors or lights. The courts ruled that public safety concerns outweighed the religious practice of the Amish, that an Amish driver of a horse-drawn buggy at night with no lights and reflectors poses a threat to not only the Amish driver of the carriage, but the unwitting driver that may not see them on the roads at night. So this notion of belief in practice is an interesting one and somewhat elusive. I've given you 3 case studies in your notes to think about to illustrate this. Obviously, your book has some others. The first one that I want to briefly touch on is the first one in your notes, and I didn't put very much there. I'll give you some additional factual information if you want, but in the Reynolds case, probably the most famous freedom of religion case in the 19th century, this case involved the Mormons. The Mormons made the claim that polygamy was an important exercise of their religion. Mr. Reynolds was the personal secretary to Brigham Young. Mr. Reynolds had 2 wives. I believe Brigham Young at one point had 19 wives and I believe 104 children. All that I have listed in the notes is that the Supreme Court outlawed polygamy in this case. So let me just give you a little bit more detail on this case. In this particular case, Justice Waite, who wrote the opinion, said that the actions of the government and what government is interested in are the actions or the practices of individuals, not the beliefs. That we're not interested in beliefs, we're not interested in opinions. And in this case, we do not believe that polygamy is in fact a belief, but instead we believe that it is a religious practice and that the government has the right to ban, to censor, or to restrict it. Now, I don't have a firm opinion on polygamy one way or the other. I will tell you that I'm personally not interested in this practice for myself, and don't think that most people who are married do. But in this particular case, other than moral disapproval, I'm not sure really what the government's compelling interest here if we're dealing with consenting adults. But the result of this case was that polygamy was outlawed, and the Mormon Church did abandon this practice about a dozen years later in 1890. The second case in your notes is the much more important one from a constitutional perspective. The group that has appeared before the Supreme Court far more than any other group in American history are the Jehovah's Witnesses. In this case, the Jehovah's Witnesses are involved. They're in New Haven, Connecticut. The Cantwells wanted to solicit anti-Catholic religious materials, books, magazines, and at that time records, and distribute them in an overwhelmingly Catholic neighborhood in New Haven, Connecticut. Now, at the time, the state of Connecticut mandated that you get a permit to solicit religious materials. The state of Connecticut made the claim that the reason that we are having religious groups get a permit from us was to prevent consumer fraud. We want to prevent people from being misled by people. One of the more controversial provisions of the law was that the state of Connecticut reserved the right to determine whether a religion was valid or not in this particular case. So the Connecticut law demanded that individuals apply for certificates or permits to engage in solicitations, and that individuals who did not get these permits or certificates were expressly forbidden to do so. And so in this particular case, the Supreme Court reasoned that the law was overreaching in regulating religious solicitations that were at the core and that were most fundamental to the ability of the Jehovah's Witnesses to converse and distribute their religious materials. Now, for me, the most important aspect of this case, what you should underline in your notes, is that the Supreme Court incorporated. Remember that all that means, the incorporation doctrine, is that principle now no longer only extends to the actions of the national government, but that action is now applicable to the legislation of the states and of local government. So in this particular case, what the Supreme Court said was, Connecticut, you must respect religious rights to the same degree as the national government. In this case, you may not require individuals to get a government permit. You are engaged in overreaching and overly regulating this activity. You are getting overly involved in the practice of religion in this case. So in Everson, remember, the Supreme Court had incorporated the Establishment Clause, and now in Cantwell we get the incorporation of the Free Exercise Clause. So in the 1940s you see the full incorporation of the freedom of religion provision in the First Amendment. Now, the provision that actually had the most scrutiny by the Supreme Court, there were a lot of cases involving the Jehovah's Witnesses in the 1940s. In fact, the Jehovah's Witnesses were involved in 23 Supreme Court cases from 1938 to 1946. There were more Supreme Court cases involving the Jehovah's Witnesses during that 8-year period than any other religion has been involved in the history of our country. So let me give you a little bit of background to these cases, because in the notes I haven't done that. In 1935, the Jehovah's Witnesses came out opposing saluting the flag as a form of idolatry. Jehovah's Witnesses, for example, had been imprisoned by Hitler's Nazi Germany for not saluting, for not raising their arm in the Nazi salute, for not worshiping the Nazi flag. And so American Jehovah's Witnesses came out against saluting any flag as a form of idolatry, as praying to a graven image. And so there were several cases after 1935 in which the Supreme Court was asked to decide whether or not the Jehovah's Witnesses had to salute the flag or not. The reason that I mention the flag salute cases is something very rare happens in the flag salute cases. Nothing that I believe I've ever seen in any other areas. The Supreme Court, by an overwhelming margin in 1940, by an 8-1 margin, ruled in Minersville versus Gabetas, the first case I have listed in 1940, that the Jehovah's Witnesses must salute the flag. In this case, the argument of the Supreme Court was that the state action was justified in promoting patriotism and national unity and national and political socialization, etc. Now, what is shocking to me is that by 1943, you have three justices, Justices Black, Murphy, and Douglas, who reverse themselves and say, in essence, we made the wrong decision. In one of the most startling confessions I've ever read by a Supreme Court justice, Justice Murphy said, "Since I joined in the Gabetas case, I believe that now is the appropriate occasion to tell you I also believe that it was wrongly decided. Certainly our historic Bill of Rights does not put the right to freely exercise one's religion in a subordinate position. I fear, however, that our decision in the Gabetas case did exactly that." And to me, what's intriguing is that by 1943, in the middle of World War II, when there is unbelievable pressure to be patriotic, to conform to standards of national unity and political socialization, three Supreme Court justices changed their mind, ruling that the Jehovah's Witnesses did not have to salute the flag, that the West Virginia law mandating that Jehovah's Witnesses school children had to salute the flag, and in West Virginia, the law that was passed mandated that the Jehovah's Witnesses and all school children orally salute the flag, or they would be expelled from school. So we're not talking about a detention or being sent home for the day. We're talking about school children being expelled from school. And in this case, by a 6-3 margin, the Supreme Court reversed its decision from the Gabetas case and ruled in favor of the Jehovah's Witnesses. To me, this is incredible to think that from 1940 to 1943, the Supreme Court went from an 8-1 margin, ruling in favor of the government in mandating that school children salute the flag, to only 3 years later, in the middle of World War II, three justices saying, you know what, I made a mistake. The government should not be forcing people to action, forcing them to salute the flag. And to me, this is a very courageous decision by the court. It is another example of a statement that I mentioned earlier, that I believe that the courts are the best vehicle to protect the rights of unpopular minorities from the power and the abuse of majoritarian tyranny. And in this particular case, the Supreme Court was able to ignore societal pressures to be patriotic, to ignore societal pressures to conform to majoritarian societal standards, and the Supreme Court courageously protected a minority religious group who was not popular and allowed them to exercise their religion in a means that was seen as unorthodox, and yet was a decision that should be left to that religious group. So in this case, the flag salute cases is an example of the Supreme Court being able to change an earlier precedent and to be, in my mind, correct. In the next lecture, we talk about criminal defendant rights.